Mr. Darling, that after today, I will not accept this plea agreement. I'll be found guilty. The range of punishment is between 2 years and up to 10.
This is one of those courtroom moments that seems small, but it's actually everything. When a judge explains the range, 2 to 10 years in prison, that's not just legal language. That's someone's entire future sitting in that gap. And what makes this moment powerful is that he's being handed a lifeline. A reduction from a third-degree felony stalking charge down to a misdemeanor. Deferred probation. No prison time. In criminal court, that kind of offer doesn't always come twice.
Good morning. Are you Charles Darling? And Mr. Darling, in cause number 24, DCCR 1384, you're charged with the third-degree felony offense of stalking from April 11th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with that of Mr. Lewis's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to plead to a reduced charge of a Class A misdemeanor of harassment for a 1-year deferred adjudicated probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll do that. I do want to make sure you understand, Mr. Darling, that after today, I will not accept this plea agreement. Obviously, if you didn't do it, you didn't do it. But this is quite a reduction and a good deal if you did. But I'm not going to accept a misdemeanor reduction after today. Once your case is set on the trial docket, it is going to go to trial, or it would be a plea to something different. Do you understand?
He says he wants trial. And listen, that's his right. Every defendant has the right to trial. But here's what makes this intense. The judge makes it crystal clear. Once today ends, this deal disappears. That's a gamble. A serious one. Because if a jury convicts him of stalking, we're not talking about probation anymore. We're talking about prison. And when a judge says, this is quite a reduction and a good deal if you did, that's not casual. That's courtroom code for, think very carefully.
All right, so we'll get it set on the trial docket, and you're appointed. Mr. Darling, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Lewis, you'll remain on. He will begin preparation for trial. Make sure you stay in touch with him. He'll let you know when you need to be back.
Right. Man, just so the record is clear, I don't have any indication that there's been any issues between the complainant and the defendant. We just admonish him again as to the no contact. I will also reach out to her again. We've had several conversations, let her know kind of what juncture we are, what she wants to do, and I'll let the court know something well in advance.
Now this part might seem procedural, but it's actually critical. Stalking cases live and die on boundaries. And the judge is doing something very deliberate here. She's removing all gray area. No contact means no contact. Not even if she reaches out. Not even if she says it's okay. Why? Because court orders aren't suggestions. They're lines in the sand.
Okay, thanks. So I want to make sure you understand, Mr. Darling, it's a condition of your bond that you have no contact or communication with Quandisha Celestine. You understand? Okay, so that means you're not to be in contact with her personally, but also you're not supposed to send messages. Don't send anything on social media, text messages, anything like that. Do you understand? If I find out, she can't give you permission to do that. So she can't say, no, it's okay, it's fine with me, come on over, or let's do whatever. She can't give you permission to violate my court order. If you violate that court order, then your bond will be raised, and then you'll be back in jail waiting on trial. Do you understand? Okay.
And I will let her know this may be what he wants to address, that goes for her as well, Judge. I think there has been some communication directed at him, and I don't want him to accidentally violate because she's doing that.
Well, I can't tell her what to do because she doesn't have a case pending in front of me. I can only tell you what to do. So Ms. Molfino is going to talk to her, but if she contacts you, your response is, I can't talk to you. Don't respond. Let her know that up front. She's going to let her know that. No more communication, no contact until this case is over. Understand? Okay. All right, you're free to go.
All right, thank you, Judge.
What stands out to me here is how calm the judge is, but how firm. She's not emotional. She's not dramatic. She's precise. If she contacts you, don't respond. That's the moment where responsibility shifts entirely onto him. And in stalking cases especially, courts don't play around with bond violations. One message, one DM, one response, and suddenly you're back in jail waiting for trial. This entire hearing feels like a crossroads. He rejected a deal that would have kept him out of prison. Now the only thing standing between him and a possible 10-year sentence is what happens next.
Good morning, ma'am. You're Diamond Ollie. And Miss Ollie, this is your initial appearance. I feel like you've been here before, right? Or no? I'm sorry? Okay. Give me just a second. It says initial, but I feel like... Did you just bond out? No? So have you already been here and I told you to go hire a lawyer and all that? You haven't done that either. Okay. All right. So I guess this is your initial appearance in cause number 25 DCCR 0532. You're charged with the state jail felony offense of injury to a child, elderly, or disabled individual, and that's from February 1st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Miss Ollie, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset note. Good morning, sir. Are you Tyron Williams?
Yes, ma'am.
And Mr. Williams, this is your initial appearance in cause number 24, DCCR 2242. You're charged with a third-degree felony offense of driving while intoxicated, third or more, and that's from March 31st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes.
Did you get someone hired?
I had to pay him his money first.
I'm sorry?
I had to pay him his money.
Who's that?
Benjamin Jeffries.
All right, so what I'll do, Mr. Williams, is reset your case about 30 days to give you some time to get Mr. Jeffries hired.
Okay.
If that works out, just bring the reset notice that you get today to him, and he'll tell you what to do. If for some reason it's not going to work out with Mr. Jeffries, then I'm ordering you to visit with at least 3 other lawyers. Bring me back the names of those lawyers when you come back to court so I know you're trying, and we'll discuss what your options are. And do you have, as a condition of your bond, the auto ignition interlock device on your vehicle? All right, make sure you keep that up and don't drive any vehicle that does not have that on it, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you the reset. Good morning. Are you Kingston Walker? And Mr. Walker, this is your initial appearance. In cause number 25, DCCR 0861, you're charged with the third-degree felony offense of tampering or fabricating physical evidence with intent to impair, and that's for March 27th of 2025. You're also charged in cause number 25, DCCR 0862, with possession of a prohibited weapon, and that's also from March 27th of 2025. And since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do is reset your case about 30 days to give you some time to try to hire somebody. If you get a lawyer hired before the next court date, just bring the reset notice that you get here today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, if you'll step in front of the clerk, she'll give you your reset note. Good morning, you're Diamond James. Did you get someone hired? Who'd you talk to?
Yeah, I called a lot of attorneys, but a lot of them don't work with criminal lawyers. I paid for it.
Why would you leave? That's the one thing that's important today is
I
to,
forgot it because I had headed into work and left work early.
where are you working?
Baymont Hotel.
Okay,
New house.
okay. So where are you on being able to get someone hired then?
I'm trying to save money so I can go with Mr. Burbank. If he want 1,500.
Okay. You work full-time at Baymont?
Yes, ma'am.
Okay. Let's see. All right, I'm gonna give you one more reset, about 30 days. Try to see if you can get him hired. If not, if you make payments, bring me receipts of those payments. I wanna know that you're saving the money and trying to work towards getting him hired, okay?
Yes, ma'am.
Step in front of the clerk, she'll give you the reset notice. Morning, you're Samuel Cadena. And Mr. Cadena, did you get someone hired?
Not yet, man. I did get a list of lawyers that I talked to.
Who'd you talk to?
I talked to Adam Parker, Walker Law, Charlie Rojas, Gertz Kelly. They're supposed to call me back, but they didn't.
Okay,
But Thomas and Adams,
all right.
I talked to all.
All right, are you gonna be able to hire someone?
I'm thinking about Mr. Parker. I was just need a little bit more time to raise the money, but
Okay.
I think by
Well,
Friday-
thank you for doing what I asked you to. What I'll do is give you about 30 more days to see if you can get him or someone else hired. If it works out, great, bring that reset notice like I said before. If for some reason it's not gonna work out with any of the ones you've already talked to, talk to a few more. You can tell from talking to them, they all have different payment plans and things like that. Step in front of the clerk, she'll give you a reset notice. Good morning, are you Kelby Blanchett? And Mr. Blanchett, this is your initial appearance in cause number 25 DCCR 0799. You're charged with the third-degree felony offense of obstruction or retaliation from May 21st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so I'm going to reset your case, give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you talked to so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Good morning. Are you Bernacia Gloston?
Yes, ma'am.
And this is your initial appearance in cause number 25 DCCR 0359. You're charged with burglary of a habitation from February 20th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I asked for a court appointment.
Right, so when you're in custody, we automatically give you a court-appointed lawyer. But now that you've made bond, I'm going to expect you to at least try to hire your own lawyer. So I'm going to reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, you're going to get a reset notice today. Bring that to the lawyer, and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you talked to, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail for not following that court order. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Say, good morning, sir. Are you Anthony Vidal?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Does yes.
Judge, you may recall on this case, we discussed maybe a restitution deal. He's in a group home, and after meeting with his team, we ended up agreeing to do a 1-year deferred to a Class A misdemeanor. If we didn't write it up right, that's on, I didn't catch it. And pay that full restitution over time.
Okay. So it's a
Class A criminal mischief.
All right, and will he waive the formal reading of the indictment?
You do it, Judge.
Mr. Vidal, in cause number 24 DCCR 2062, the state has elected to proceed on the lesser included offense of a Class A misdemeanor criminal mischief from July 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for 1 year deferred adjudicated probation. There would not be a fine, but there would be restitution in the amount of $3,025. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Bless you. Is there any evidence that Mr. Vidal is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year.
Yes, ma'am.
You're ordered to pay restitution in the amount of $3,025 and to follow all of the other rules and conditions of probation. If you do all of that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you're successful, the case is dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork, and she's at that desk right there, so just watch for her to call for you, okay? All right, good luck to you, sir. Thank you.
Thank you.
You're Kendrick Walker? And this is 24 DCCR 0196. Mr. Walker was previously in court, entered a plea of guilty to unlawful possession of a firearm by a felon. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We haven't.
Yes, Your Honor, I have.
Any additions or corrections?
There is one that we would like to bring to light, Judge. We spoke quite a bit this weekend. On the defendant's version, there was a little bit of an inaccuracy. Mr. Walker had specified that when he was in the vehicle, he did not put the firearm in the vehicle, but he did learn that there was a firearm in the car and realizes that he should have gotten out of the vehicle and left at that point.
Okay.
So that was it was a little unclear with that. So we wanted to just clarify that part.
So I also want you to understand, Mr. Walker, the opportunity that you're being given today, you've already had a felony probation that was revoked, and it wasn't that long ago. So the fact that you're getting a probation in this case is a real gift, and so if you want to make sure you understand that you need to follow all of the rules. If you're back in here, it's not going to be on a revocation or because you didn't do it, oh, give me another chance. This is your other chance, okay? All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made. Find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with that agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections, but probate that, you'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. Obviously, if you do that, again, this is a great opportunity because you're going to be able to serve that 10-year sentence while you're out on probation. The other side, though, if you're back in here, you've already agreed to a 10-year sentence. And so, please make sure you follow all of those rules. I'm going to hand you the trial court certification that shows, Mr. Nichols, that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this at this point, but I am required to read this by law. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, Read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. And again, as you can tell, it doesn't even have to be yours to be in possession of it. You can't be in a car with a gun, in a house with a gun, anything like that, okay? All right, have a seat here in the courtroom. Probation will call you up when they're ready to go over your paperwork.
Thank you, Your Honor.
Thank you, Mr. Rennick.